Well, the adversary proceeding just continues. It's not as if that's going to halt. With regard to the bankruptcy case, it does depend on what kind of adversary proceeding we're talking about. Let's talk about the kind of adversary proceeding that's perhaps the most common, and that is a challenge to the discharge of a debt in a personal bankruptcy case. So let's say, for argument's sake, the case is under Chapter 7. Well, the Chapter 7 case will still continue apace, and you can still get your discharge. But what will still be pending is the determination of whether or not that particular debt that is the subject of the adversary proceeding will eventually be listed among the discharged debts. If you lose the adversary proceeding, then while you'll still have the discharge, that particular debt will not be discharged. It will be accepted from discharge. That's perhaps the most common. That also comes up in a Chapter 13 case, which involves a multi-year debt repayment plan that's administered by the bankruptcy court. For debts that are dischargeable, those debts typically don't necessarily have to be paid back 100% through the life of the Chapter 13 plan. So what that means is you could conceivably pay them at a low percentage. But if that dischargeability adversary proceeding is still pending, well, you can get the plan confirmed with the understanding that once that adversary proceeding has been concluded, if it's determined that that debt is not dischargeable, then at the completion of the bankruptcy case, the unpaid portion of that debt will still be owing. You'll still get credit for the amount that you paid through the plan towards that debt. But if it's determined to be non-dischargeable at the completion of the plan, the unpaid portion you will still owe. So in Chapter 11, it's a similar sort of thing. In Chapter 11, and I'm talking about a personal case because the non-dischargeability issue really doesn't come up in a business case. In a personal Chapter 11, you can still face that adversary proceeding to determine the dischargeability of the debt. And if you lose, well, you may need to modify the plan. That's going to affect the voting on the plan. So the judge may decide to stay the bankruptcy proceedings pending the conclusion of the adversary proceeding, because if the debt is determined to be non-dischargeable, it changes the nature of that debt. It could be, depending on who your judge is and what you present to the judge, that you could get the plan confirmed, but then there would be the understanding that at the completion of the plan, you would still owe the unpaid portion of that debt, or you may have to modify the plan to increase payments to that particular creditor. The wrinkle in a Chapter 11 is if you do that kind of modification, you may need to resubmit the modified plan to all the creditors so they can vote on the modified plan, which becomes a new plan. That's why you might find that the confirmation of the plan will be stayed pending the completion of that adversary proceeding. There are, of course, other kinds of adversary proceedings. There might be an adversary proceeding to avoid a fraudulent transfer or a preference. In each case, that's not necessarily going to stay the underlying bankruptcy case, but it will mean that that adversary will have to proceed until completion. In a Chapter 7, the motion to avoid the fraudulent transfer or the preference will be done by the Chapter 7 trustee appointed to the case. That does not necessarily affect the dischargeability of a particular debt. However, if the debtor has done a fraudulent transfer within the 12 months prior to filing the bankruptcy petition, then the debtor will be ineligible to get a Chapter 7 discharge. So as a result, don't engage in fraudulent transfers. And I've done previous videos on fraudulent transfers. You can take a look at those, or give me a call and say, you'd like to get more information about what a fraudulent transfer is. That's a very sophisticated area of law, by the way. It's been around since ancient Rome. So whatever tricks people think they're going to put forward to overcome the strictures of that law will not work. Now, in a Chapter 13, you rarely have any kind of avoidance actions on fraudulent transfers or preferences because Chapter 13 trustees are really not interested in that sort of thing. And there is case law holding that the debtor does not have the authority to avoid those transfers. In a Chapter 11, on the other hand, there's usually not a Chapter 11 trustee unless something's gone dreadfully wrong. Instead, the debtor serves as a quasi-trustee called the debtor in possession. And that debtor in possession then has the same authority as, say, a Chapter 7 trustee to avoid fraudulent transfers or preferences being pre-petition payments to creditors, giving them more than they should have gotten within a certain time window, depending on the kind of creditor. And so that may hold things up, getting the plan confirmed, because part of the funding of the plan may be using the proceeds of the avoidance action of the fraudulent transfer. Now, if it's fraudulent transfer, avoidance action to avoid not transfer of money, but an asset, then once that asset is brought back into the bankruptcy estate, the debtor in possession will probably have to conduct a sale, an auction in the bankruptcy court to get money, but that would still go towards funding the plan. So there, the adversary proceeding may put the underlying Chapter 11 case on hold until it gets resolved. By the way, a certain amount of what I've been saying may become a little bit clearer if you think of things this way. Prior to filing the bankruptcy case, the debtor has assets and the debtor has debts, obligations to creditors. When the debtor files a bankruptcy case, the assets go into a bankruptcy estate that's created upon filing the petition. And then the debts become claims against that estate. If it's an individual case, we take stuff out of the estate using the exemption process. Anything we can't take out is still there in the estate to be used to pay claims. So in a Chapter 7, that estate is used by the Chapter 7 trustee to pay creditors. In a Chapter 11, it's used by the debtor in possession to pay creditors. And in a Chapter 13, while you get to keep all your possessions, the value of that estate goes into determining how much you have to repay over the life of the plan. A similar sort of analysis does apply in a Chapter 11 case. A bit of a long-winded answer, but I thought it was a fairly open-ended question that deserved a more complete answer than one might have thought first hearing the question.